first part of the program this morning was really just a warm-up. We've kind of gotten everything out of the way that isn't really directly related to the mandate. The mandate, of course, is the main event today. This is the piece that will have potentially the most significant impact on your business. So that's what we're going to jump into right now. And I want to start with talking a little bit about the big picture. This might come as a surprise to you, but I can tell you that a lot of the employers that I work with on this issue, the focus is, how can I get out of it, right? How can I shrink my business under 50? Can I break up my companies? Can I use, a labor contractor? There's got to be a way for me to fly my business under the radar. I just can't accept the fact that I may have to deal with this. And there are a lot of planning opportunities, and we're going to talk about some of those today. But I think it's important to remember sort of the what I call the policy backdrop with healthcare reform. The primary goal of this legislation is to get people covered. And so if you as an employer are maneuvering around and engaging in certain types of things that are against that policy, right? You're trying to get under the radar so you don't have to offer coverage, let the employees fend for themselves. Just remember, don't get too aggressive, because the regulators are looking at everything through the lens of this policy that we need to get everybody covered, and that you as employers, sort of like it or not, have a big role to play in that. If you go all the way back to 2009, 2010, when healthcare reform was moving its way through Congress, I mean, certainly one option, at least in theory, was single payer, universal health care, whatever you want to call it. The government provides everybody coverage, as opposed to this system that we have. Politically, that wasn't going to work. So we ended up with this system that basically keeps employers as a significant part of the process. The tools, again, for getting people covered, in my view, the primary tools, we have that individual mandate, which maybe not this year, but eventually is going to encourage everybody to go out and get coverage. We have the exchanges that are there to kind of pick up all the folks that don't get coverage elsewhere. And then we have that third pillar, which is the mandate, which keeps employers in the game. So there's a definite role to be played by employers, like it or not. Now, I do a lot of work in the agricultural industry, and there seems to be an assumption out there that there's got to be an exception for us, right? It doesn't make sense that we would have to deal with this. Our business is unique. The demographics of our workforce are very unique. There's got to be an exception for us. And again, don't shoot the messenger, but I hate to tell you, there is no exception for the ag industry. And just to kind of put that in perspective, there's no exceptions for religious organizations. There's no exceptions for not-for-profits. There's no exceptions for governments. Small, state and local governments have the same obligations under this law that you as employers have. So just keep that in mind. The other thing is, I just want to make sure it's clear, there's no exception for guest workers. So for those of you who are, using the H-2A program and guest workers, don't assume that those folks just don't count. They count like any other employee, and as I talked about earlier, if they're lawfully present in the U.S. under that visa, they have the same obligation as any other individual here to have coverage. So just keep that stuff in mind as we walk through the mechanics of it. So as I mentioned earlier, the mandate applies starting next year to employers who, on average, had 50 or more full-time employees and full-time equivalents. Now, that sounds simple enough, 50 or more, right? But like anything else where the IRS is involved, it's not so simple. There's a lot of mechanics that go into the test, so I want to walk through that, make sure everybody is clear how this works. So you have to start with, who counts as a full-time employee? Well, for purposes of this test, this 50 or more test, anybody, you look at it month by month. And for each month, if somebody works at least 130 hours during that month, they are considered a full-time employee. Now, where did that 130 come from? Well, the basic definition of a full-time employee is somebody who, on average, works 30 or more hours a week. If you do the math, 4 1/3 weeks in a month times 30, that gets you to 130. So that's where IRS got this 130-hour standard. So for each month, you're gonna figure out how many full-time people you have. And the way this works is you're always looking back to the prior year. So if you want to figure out whether you are subject to the mandate in 2015, you have to look at your employee counts during 2014. So that means, as we sit here today, your employee counts matter. January's already in the bag. So let's talk about how you would count your employees for purposes of this test. And we'll just take January as an example, since that one's in the bag already. So you're going to go back and look at your employees for the month of January. For everyone that worked at least 130 hours, they count as one full-time employee for the month of January. Now, you may have people who worked 300 hours in the month of January. Believe it or not, nobody's ever going to count as more than one person, okay? So you're not going to count them as two because they worked 300 hours. If they hit 130, they count as one, you're done with them, all right? That's going to give you a number of full-time employees for the month of January. Then you're going to look at all your part-time employees, the folks who worked fewer than 130 hours during the month of January. For them, you're going to add up all of their hours. And then you're going to divide that number by 120, take it out to 2 decimal points, and that's going to give you a number of full-time equivalents for the month of January. Now, some of you may be saying to yourself, wait a minute, I thought you said it was 130. You didn't mishear me. For some reason, they decided that the rule for counting full-time equivalents, you divide it by 120. That's just the way the rule works. Frankly, I don't think it makes sense, but they didn't ask me. I'll take questions in just a second. So that's going to give you a number of full-time equivalents. So you take your full-time count, you add that to your full-time equivalent account for the month of January, you're going to have a number. That's January. You're going to go through that same exercise for each month of the year this year. Again, take it out to 2 decimal points. Then when you get to the end, you're going to add it up. And then you're going to divide by 12, which will get you a monthly average. If that monthly average is 50 or more for 2014, then you're a large employer for 2015, subject to the mandate. Now, if you do that math and it comes out to 49.8, guess what? You don't have to round up. It's under 50. All right? It has to equal 50 or more. So if you come out to 49.8, congratulations. You got it right under the radar. But that's the basic mechanics of the test. Now, I mentioned earlier that when the IRS proposed rule came out, they said, well, for the first year, instead of looking at all of 2014, we'll let you pick a 6-month period somewhere and use that. Just use your employee counts during that period. That would be very helpful, I presume, to some of you in looking at your average for the year. I don't know whether we're going to end up with that, so I wouldn't count on it. But in any event, you're going to want to keep track of this throughout the year. Maybe when you get to the 4th quarter and that average is at 51.2, you might want to consider what your staffing needs are for the rest of the year. Maybe you can, fly it in under the radar by changing your employee counts during the last several months of the year to get your average down. But you're not going to know unless you're keeping track of the math throughout the year. Now, a couple things to keep in mind about the 50 or more test. I already mentioned it's based on last year's count, and just to hammer that home, let's say you end up at 55 employees on average for the year. So you're subject to the mandate in 2015. But in January or February of next year, you lay off a bunch of folks. Maybe you sell a piece of the business, something like that. You're all the way down to 25, 30 employees. Doesn't matter. You're still subject to that mandate for all of 2015 because you're looking back to the prior year. By the same token, let's say you fly it in at 49.8, then you get to January and you staff up. Maybe you're up to 70 or 80 employees, you acquire another business, expand in some fashion. You're still not going to be subject to the mandate in 2015 because it's based on the prior year's count. So keep that in mind. Now, earlier somebody talked about having different businesses. That's a very important thing to keep in mind. The 50 or more test is based on what's called your controlled group. The concept of a controlled group is an old tax code concept that basically takes closely related companies and treats them as one for certain purposes. Well, that's what happens with this 50 or more test. There's two ways that businesses might be combined for purposes of this test. One is if there's a parent-subsidiary relationship. So just to take a simple example, you have maybe a holding company or a parent company that's your primary business, and then you have some subsidiaries underneath that do different things. As long as each of those subsidiaries is at least 80% owned by the parent company, they're all going to be treated as a single business for purposes of this 50 or more test. The other type of controlled group is what they call a brother-sister control group. And this is where there might not be a common parent company, but you have the same group of individuals that own multiple businesses. So maybe you have a couple of brothers, and they each have a 50-50 stake in 3 different businesses. Because the 2 brothers together collectively own 100% of all 3 of those businesses will be tied together as a control group and treated as one for purposes of this test. And remember, all that matters is ownership. So the example that I like to use is, maybe you're an entrepreneur and you have a farm, you have a car dealership, and you have a gas station. 3 completely separate businesses, separate industries, really no connection among the 3 other than you own them. Doesn't matter, because if you own 100% of all 3 of those businesses, all 3 are going to be treated as a single employer for purposes of that 50 or more test. Okay? And with the brother-sister controlled group, generally what you're looking for is that 80% common ownership with either one individual or a group of individuals. So once you get beyond there, it gets to be fairly complex. But I get this question a lot where somebody says, well, no, wait a minute. Why don't I just take my business? I got 200 employees, and I'll just break it up into 4 or 5 separate businesses or separate companies with 40 employees each. Well, if all you did was form 4 new companies and kind of get everything dispersed, but you still owned everything, it's not going to do you a bit of good for purposes of this test. Likewise, if you took your existing company and just dropped some subsidiaries down there and maybe dropped some other businesses down, it's not going to do you a bit of good for purposes of this 50 or more test. Really, the only way you can either break up your business or take multiple businesses and try to get them isolated for purposes of this test is going to be to bring in true blue third-party ownership of at least 20% of the business in general. Okay, so go back to my guy that owns the farm and the gas station and the car dealership. If I found somebody who was interested in buying a 30% stake in my car dealership, somebody that's not a family member, not an employee of mine in any of the businesses, true outside owner, then I might be able to get that car dealership outside the group, if that's what makes sense. What I find in most cases is if you're just trying to reshuffle things, maybe pull in a family member, pull in one of your long-term employees and give them a piece of one of the companies, that kind of things, by and large it's not going to work because the rules contemplate that you might try to do this kind of thing, and there are lots of traps in the rules where, for example, let's say you give your son 30% of the car dealership. In a lot of cases, you're going to ignore the fact that your son owns 30% for purposes of doing this evaluation because he's a family member, and so that's really not going to get you anywhere. So, there may be some planning opportunities for those of you who are looking into something like this. But just, and the only way you can do it is you're going to have to sit down with an accountant or a lawyer like me that knows the rules and can kind of figure out how to sort through it. In most cases, what I find is it's the tail wagging the dog. That sure, it'd be great to get it under 50, but by the time you look at what you have to do to make that happen, it's the tail wagging the dog. It's gonna be much more of a business change that is something that you don't necessarily want to pursue just to kind of deal with this particular issue. Question? If you own 100% of it, yeah, absolutely. Yeah, even if you have an unincorporated business, you're still going to look at who. Usually, an unincorporated business can be 100% owned by somebody, right? It's a sole proprietorship. Yeah, those two are going to be tied together. That's right.
How do you figure full-time if you're paying piece work?
Yeah, they really don't have a good workaround for that. If you are paying people by piecework, what the rules say is that you have to come up with some system that will attribute a number of hours to the person as far as how often they're working. And the only thing that we can get out of the rules is the rules say, well, if you don't keep track of hours, you can use what they call equivalencies, where you could say, okay, I don't know how many hours a day this person works, but for each day they work, I'm going to credit them with 8 hours a day or 10 hours a day. Or for each week that they work, I'm going to credit them with 40 hours for the week, regardless of what they actually work. And all of these equivalencies, of course, are skewed towards probably giving people more hours than they're actually working, because that's intentional with the rules. So if you're doing piecework, you could try using the equivalencies. In most cases, though, it's going to put you over that 30-hour mark just because of the numbers that you have to use. What I've had a lot of clients do is have people keep track of their hours even though they're getting paid by piecework. Turn in a timesheet. You could even have them clock in and out if that's what makes sense. But you're going to have to figure out something. There's no universal way to basically translate a particular piecework into a number of hours.
Those subs, 1099s, not count?
1099s, yeah, so, well, you beat me to my last point. And that is that this is based on what's called the common law employer. So when you're adding up the number of employees, you are counting folks that are your common law employees, which normally is going to be just those folks on your payroll who are getting a W-2. There are two situations, though, that I think you need to keep in mind. One is the 1099 independent contractors. I probably don't have to tell you, but I mean, there's all sorts of potential risks when you treat somebody providing services to you not as an employee but as an independent contractor. There are lots of plaintiffs' lawyers and government agencies that would like to call into question whether that's the appropriate treatment. If somebody is a true blue third-party contractor and you're giving them a 1099, then they don't count. But just remember, if you're getting aggressive with paying people as contractors instead of employees, that all the risks associated with that, you can add this one to it, that they may end up counting as an employee for purposes of this test. The other thing that I think is worth mentioning is labor contractors. If I work with a lot of folks, particularly out in California, where they may have 30 people on their payroll on average throughout the year. But there are times of the year where they're using labor contractor and they have hundreds of people that they're paying through a labor contractor. And so that, of course, begs the question, well, who's the employer of those folks that you're getting from labor contractor? If the labor contractor is the common law employer, well, then it's his problem, not yours, right? You have 30. That's all that matters to you. But as some of you probably know, this who's the employer question can get, it's much more gray than black and white, particularly with farm labor contractors. So if you are not going to count your farm labor contractor folks, you're going to want to get comfortable that you couldn't be accused of being their common law employer. You're going to want to look at the contract that you have set up, and you're probably going to look at how your operations work, and you're going to want to shore up that No, the labor contractor is the employer, not me. Now that's something you should do for a lot of reasons, not just for this reason. But just keep in mind, you can add this to the list of risks associated with independent contractors and farm labor contractors if you're not drawing those lines as brightly as they ought to be. I have an example just to kind of walk through. I know I kind of already talked through it. So you look at the month of January, 40 full-timers. You have 5 additional employees, 100 each. So that's 500 hours total, divided by 120, go out to 2 decimal points, 4.17. So in this particular month, in this example, 44.17 employees. Do that for each month of the year, add it up, divide it by 12. And the question is it 50 or more? That's the way the test works. Now, there is an exception in this test. It's called the seasonal worker exception. And this is an exception that I think in some cases will be useful to ag employers. Now, first you have to ask yourself, well, who counts as a seasonal worker? Right? It's sort of in the eyes of the beholder as to whether or not somebody's seasonal. The IRS has given us a definition. It's in your slides. And if you look at this definition, I think it's very clear that agricultural labor, farm labor, counts as seasonal labor, assuming that it is seasonal. It's not somebody that's on your full-time payroll for the whole year. They've even made it clear that you can have somebody who, in effect, works a full-time schedule year-round, but they're working for multiple people throughout the year. Maybe they're going south in the winter, and that's okay. They still count as a seasonal worker. So I think it's clear in this industry, as opposed to some others, that your seasonal farm work is going to count as a seasonal worker. So the way this works is, if your regular non-seasonal employee count averages under 50 throughout the year, and you only balloon up above 50 for 120 days or fewer during the year, and when you do balloon up above 50, it's because of seasonal workers that you're bringing in, then you won't be considered a large employer even if you average out to 50 throughout the year. So I'll give you an example. I have a client in California that has about 45 regular full-time employees on their payroll year-round. Well, from about May, let's say May to September, they staff up. They add hundreds of additional seasonal workers during those months. And because they're adding so many employees during those months, it takes their average for the year way above that 45 regular workforce. That's the situation that this rule is attempting to address. That if most of the year you're under 50, but for 120 days or less you're going up above, as long as the only reason you're going up above 50 is seasonal work, then you won't be considered a large employer. Now, I represent a lot of ag businesses in the South that have year-round operations. This rule doesn't do much for them. I mean, they may have seasonal work, but they're just bringing in different seasonal work at different times of the year. It's a year-round operation. Up north, if depending on what kind of operation you're running, this may be something that helps you out. If you're only bringing people in for 3 or 4 months to staff up, during a season. It just depends on your operations. But keep in mind, this is it's not that free pass we're all looking for. It's not that big exception you can drive a truck through for the ag business. Seasonal workers still count as workers, for other reasons, particularly if you are a large employer. It's not that you just get to not consider them at all. If you fit into this narrow exception, then you won't be a large employer. So keep that in mind if you fit into an example like that.
Well, the H-2A would fall under it, possibly.
An H-2A guest worker is going to count as a seasonal worker. Okay? Now remember, I said it's not that you get to disregard them, but they will certainly count as a seasonal worker for this purpose. So if you're bringing in H-2As for 2, 3, 4 months at a time, and that's the only reason that you're averaging above 50, you may be able to take advantage of this exception. Do you have a question?
So we're open basically for 5 months of the year. We have one full-time employee in the off-season plus the employers, the owners. And if we get like 40 in June, 40 in July, and then we balloon up for a couple of months.
Well, for you, though, you might not even need this rule, because by the time you add up all those months where you only have one person, it's going to dilute your average across the year. So you might not even need this. This is for the employer who, it's only because of that seasonal work that their average gets pushed up above 50 for the year. That's where this rule comes in.